Welcome to the third of the Week 4 podcast on the bias rule of natural justice. All the issues we just considered in the previous podcast were part of the hearing rule, and the second limb of natural justice is the bias rule. This second limb is not used as frequently in practice, but it can be used and it does arise in some of the scenarios that we look at in this unit, so it's important to know about. Bias can be actual, that is, a deliberate, intentional finding against someone because of bias. And there is also ostensible or apprehended bias. Would a reasonable person suspect there is bias, whether or not that objectively is the case? The latter focus on apprehended bias is our primary focus here. There was a 2015 High Court case of Isbester and Knox City Council which looked at bias issues and neatly lays out a nice three-step test which you can use if you are looking at bias in a hypothetical problem scenario. The first step is to identify the factor which it is hypothesized might cause a question to be resolved otherwise than as a result of a neutral evaluation of the merits. And this factor needs to be identified with some precision. Is it a financial or monetary connection that is the problem? Is it a family connection or close personal relationship that is the problem, etc. The second step is to articulate how the identified factor might cause that deviation from a neutral evaluation of the merits. So what's the connection between the factor identified in the first step and the actual decision that was made? The third step is to consider the reasonableness of the apprehension of that deviation being caused by that factor in that way. Is it close enough to be considered a logical connection? The test for the rule against bias is an objective one. That is there a reasonable apprehension of bias? And the authority for this is the case of Ebner, an official trustee in bankruptcy. The test is the same for pecuniary and non-pecuniary bias, although economic conflicts are likely to be particularly significant. Again, the authority here is Ebner. This was a case about bankruptcy, and the judge had a financial interest in a bank connected with the litigation before them. So was this enough to make the judge biased? The answer, according to the High Court, was no. There was also a sense in this case that the parties were using the rule against bias to do a bit of forum shopping to get their case heard before the judge that they wanted. The High Court said apprehended bias in this case was too remote and put an end to the forum shopping. How much special knowledge do we attribute to the reasonable bystander? A key case here is British American Tobacco, or BAT, and Laurie. The facts here were that Miss Laurie was suing BAT in negligence on her husband's behalf in the Dust Diseases Tribunal. The essence of her claim was that BAT owed Laurie a duty of care and was negligent because it knew that smoking caused cancer. In support of this, Laurie argued that BAT had adopted a policy of destroying documents which pointed to the link between smoking and cancer. In an earlier and separate case called the Mowbray proceedings, Justice Curtis had decided that BAT had destroyed documents of this kind. BAT argued that Justice Curtis was biased against it and should be prohibited from hearing the Laurie case. The High Court said that the test is whether a reasonable lay observer or a hypothetical observer might possibly apprehend that the decision maker had prejudged the case. So is the judge likely to be biased by a decision made 3 years ago in a completely unrelated case? Would it appear this way to the reasonable bystander? Would the ordinary bystander know that judges are people of high moral character that must be impartial in every case before them? The High Court said, no, we do not attribute this special knowledge of high moral character to the reasonable bystander. And they therefore said that there would be a reasonable apprehension of bias in this instance. If you think about it, if the court had decided otherwise on this point, no claim of apprehended bias against a judge could ever be made out. One of the factors affecting a finding of apprehended bias in this case was the definitiveness with which the judge expressed his findings that BAT had fraudulently destroyed documents. There was no qualification or doubt in the way it was expressed, so it was not framed as some kind of tentative opinion. So this is something to look for in a problem scenario or in an exam situation. Has an opinion been expressed in a way that is definitive and unequivocal? Or is there some kind of qualifying or nuanced language? If there is evidence of the latter, this is less likely to indicate bias. Bias may also be established by evidence of a consistent cumulative pattern of behaviour by the decision maker. An example of this is the case of Kitching and Commissioner of Police. The facts of this case are probably familiar to some of you. In 2004, an Aboriginal man on Palm Island died whilst in police custody. He was a young man who had never come to the attention of the police before. He'd been arrested for being a public nuisance and dragged into the station and somehow died overnight in the station. The man who died had very severe injuries consistent with a beating. For example, his liver had been split due to broken ribs. As you may be aware, there were riots on Palm Island in the wake of the Aboriginal man's death. A police officer called Chris Hurley was prosecuted for manslaughter but found not guilty. Before Hurley was prosecuted, police were sent up to Palm Island to investigate what happened. Those police officers sent up were friends with the officers on Palm Island, who invited them over for a barbecue at the police headquarters. One of these men was called Kitching, that is, he was the Kitching that is referred to in the case name. And it is perhaps unsurprising that after the barbecue, the police officers sent to investigate the death found that the death was no fault of the police, which was very controversial in the broader community at the time. In light of these events, the Crime and Misconduct Commission got very strident about the need to change police culture in Queensland. The Commission said that unless decisive action is taken, the reputation of the police would be seriously damaged. The Commission made adverse findings about the original investigation undertaken by Kitching and his colleagues and recommended disciplinary proceedings be taken against the officers involved in the original investigation. The Commission asked the Commissioner of Police to respond to the recommendations in 14 days, accompanied by reasons, and if there was no response, disciplinary proceedings before QCAT would be commenced. The Commission then said publicly that the Commissioner of Police's contract was due for renewal soon, which came across like a veiled threat. The Commissioner of Police then replied, saying that he would work day and night to meet the Commission's deadline. Did the pressure that the Commissioner of Police experienced in this situation indicate bias in relation to the inquiry into the police officers on Palm Island and the ones who did the follow-up inspection? The Supreme Court held that this pattern of behaviour was consistent with apprehended bias, that the police commissioner would not be open to evidence of the officers involved. Therefore, he could not personally be involved in the investigation, but he could delegate the matter to another officer. What is the case for ministers? We know that a minister is an elected official who has a role that is necessarily political to some extent, and we cannot expect the same level of impartiality from a minister as we might from a judge, for example. Making political comments is not enough to necessarily indicate bias unless the policy is being applied without regard to the merits of the case. A key case here is Minister for Immigration and Jar Lagang. Jar had been convicted of rape against his former partner and his visa was cancelled on character grounds. The AAT overturned the cancellation and recommended that Jar's visa be reinstated and adopted a far more favourable version of events. This decision caused a public outcry, and the minister was displeased with the AAT's decision in this and a similar case. The minister went on Talkback Radio and commented specifically on Jar's case, saying, "I don't think someone who has been convicted of rape can be of good character. I am looking into my options, including cancelling the visa." He also wrote to the AAT to discuss/complain about this issue. Then the minister cancelled Jar's visa and declared him to be an excluded person, and Jar brought a case to say that the minister was biased against him. The matter was heard before the High Court and concerned review for both actual and apprehended bias. On the issue of actual bias, Chief Justice Gleeson and Justice Gummow said that the state of mind described as bias in the form of prejudgment is one so committed to a conclusion already formed as to be incapable of alteration, whatever evidence or arguments may be presented. Natural justice does not require the absence of any predisposition or inclination for or against an argument or conclusion. Which of course makes sense given that we are all subjective in our viewpoints on a range of different issues. The High Court found that there was no bias in this case because, firstly, the minister's statements must be considered in light of his political functions and responsibilities. He is allowed to follow policy, but not above or instead of the law. Secondly, his statement did not reflect a concluded and unalterable view of the law, and he did not appear to have prejudged the case. A couple of other cases involving ministers are Hot Holdings and Epiabaka. The case of Hot Holdings and Creasy concerned a situation in which two people who prepared a report and advised the decision maker had a pecuniary or financial interest in the outcome. Two departmental officers had shares in a company that had options to purchase shares in a mining company that was going to be granted a mining lease. The question was whether the minister was vicariously liable because two of his advisors had a remote pecuniary interest in the outcome of the decision. The High Court said, no, that is too remote to constitute vicarious bias. The minister, as the ultimate decision maker, is the one who has to turn his mind to the issues and make the final decision. What if a tribunal member makes a comment after the case? In the case of Epiabaka, AAT members involved in a decision wrote a blog 10 months after the case. The comments were something like, "I get a lot of liars, people make up what they want." But these comments were also balanced by other comments indicating the members felt sorry for refugees and get a lot of genuine applicants. These comments were weakly criticised by the High Court, but they were not considered biased. Okay, so in summary, there is no grounds of automatic bias. So for example, because the decision maker has a financial interest in the matter won't be enough in and of itself to constitute bias. In every case, we need to produce evidence that the decision maker either had actually prejudged the case or that a reasonable lay observer might apprehend that to be the case. To understand where natural justice obligations do apply, it's also helpful to look at where they may not apply. A party may be treated as having waived their right to insist on observance of the bias rule, for example, where they elect to continue participating in a decision-making process without raising an objection, and/or they only raise an allegation of bias after an unfavourable final outcome. That is, they only challenge the process if they didn't get the outcome that they wanted. This was confirmed in the case of Vakauta and Kelly. It should be noted, however, that it is difficult to establish that a person has waived their obligation to fulfil natural justice, especially in relation to bias. In some circumstances, the doctrine of necessity may constitute an exception to the bias rule. This may be the case where circumstances are such that the particular decision maker, who would otherwise be disqualified by reason of the rule against bias, is the only person authorised, competent, or able to decide the relevant matter. So this will depend on the legislation and the decision-making structure. The principles of waiver and necessity do not arise frequently in practice, but it's still good to be aware of them. What is the situation where there are problems with natural justice in the original hearing, but there is an appeal avenue available which affords natural justice? Does this cure the original breach of natural justice? The case of Calvin and Carr tells us there is no clear or absolute rule on the question of whether defects in natural justice at an original hearing can be cured through an appeals process. However, courts typically expect applicants to have exercised their lower appeal rights before seeking judicial review of a decision. In the case of Mia, Justice McHugh listed a variety of factors to take into account here, including firstly, the nature of the original decision. Was it a preliminary or final decision? Secondly, is the original decision made in public or private? Thirdly, are formalities required for the original decision? Fourth, is the original decision an urgent decision? Fifth, what is the nature of the appellate body? Is it a judicial, internal, or something less than a tribunal type of body? Sixth, what is the breadth of the appeal? Is it an appeal de novo, that is from scratch, or is it a limited appeal? If it's a limited appeal, then maybe natural justice should apply because otherwise some relevant considerations may be missed. And 7, what is the nature of the interest and the subject matter? What are the consequences then if there is an unfair hearing that is affected by a failure to accord natural justice? We'll talk more about remedies in the Week 9 podcast, but just to briefly introduce this topic here, we can distinguish the remedies that are available under the ADJR Act or the JR Act of Queensland and under common law. So under the ADJR Act, natural justice is a ground of review under sections 5 and 6, and the equivalents are in sections 20 and 21 of the JR Act of Queensland. In terms of remedies, the court can make any order it thinks fit under section 16 of the ADJR Act and under section 30 of the JR Act of Queensland. At common law, a failure to comply with rules of natural justice is usually treated as a jurisdictional error, which was confirmed in the case of Refugee Tribunal ex parte Awa. As we'll discuss further in week 7, If a decision is affected by jurisdictional error, it is treated as being legally void. So the High Court could issue a writ of mandamus to compel the decision to be remade if the decision maker was under a duty to do so, or it could issue a writ of prohibition or injunction to stop the decision maker acting on the decision, and this would depend on the facts as to which remedy was most appropriate. So this brings us to the end of the materials on natural justice and procedural fairness. Let's look at a revision question on bias before we finish. The question is, the test for apprehended bias is A, would a judge consider that the decision maker is incapable of bringing an impartial mind to the resolution of the matter? B, has there been a financial benefit to the decision maker or someone connected with the decision maker? C, would a reasonable bystander consider that the decision maker is incapable of bringing an impartial mind to the resolution of the matter? Or D, has the decision maker said something that is biased, for example, making public statements about the case evidencing prejudice? What do you think? The answer is C, and we know this from the case of Ebner and official trustee in bankruptcy. A is not quite right because we know from BAT and Laurie that we don't expect a reasonable bystander to know that judges have particularly high moral standards, and it's also not a matter of whether the judge would consider whether there is bias in this instance. The test should be what a reasonable bystander thinks constitutes bias. B is not correct because this is only one form of bias, and non-pecuniary bias is also possible. D is not correct, although this may be one form of bias, and especially where the decision maker is a politician, this will be unlikely to be successful. So this brings us to the end of the materials for week 4. Don't forget to ask any questions you may have via email, on the discussion forum, or in consultation hours. Thanks everyone, and see you next week.